Good morning and welcome. Welcome to those of you who are here. Welcome to those of you that are viewing this via webcast to this year's Supreme Court Preview Conference of the Center for Business Law and Regulation, co-sponsored with the Corporate Law Practice Group of the Federalist Society. We are thrilled to have you here this morning to discuss for the next several hours what has been called the most important securities law case to reach the Supreme Court in over a decade. In fact, it turns out yesterday on NPR, in what might have been a little bit of hyperbole, this case was even referred to as the Roe versus Wade of securities law. Whether that characterization is accurate or not, this is certainly a very important case, and a case that some of us feel probably has not gotten the attention it deserves, like many business law cases that go before the Supreme Court. I want to say a little bit about the Center for Business Law and Regulation and its programs. Introduce Dean Reuter, who's from the Federalist Society, our co-sponsor, and then we can get right into our first panel. The Center for Business Law and Regulation was created here a few years ago to help augment and enhance both the curricular and extracurricular offerings of Case Western Reserve University School of Law, and also provide programs such as this relating to business law and regulation. It covers the waterfront of legal issues that relate to the intersection of law and business, from securities law and corporate governance to questions of environmental regulation and land use, financial sector integrity, international trade, and everything in between. We sponsor courses for students and extracurricular programs, and public lectures and public conferences like our program today. Another one of our programs next week, coincidentally on Tuesday, October 9th, the very same day that Stoneridge will be argued before the Supreme Court, we are sponsoring the annual Norman A. Sugarman Tax Scholar in Residence Lecture, which will be given by Professor George Yin, who is a law professor at the University of Virginia, who will be speaking on temporary effect legislation and fiscal responsibility. So after you've read the early press reports about what happened on the Supreme Court in the Stoneridge oral argument, you can come here or view by webcast Professor Yin's lecture, tax law lecture, and then afterwards you can go to your computer and check back with our website to see updates about what occurred at the Supreme Court next Tuesday. We will be posting materials, links to news coverage, the transcript of the oral argument, and other materials from our speakers and others on what occurred Tuesday and how maybe that should affect our understanding of the case. If I want to turn the mic over for a moment to Dean Reuter, who is Director of Practice Groups from the Federalist Society, who is co-sponsoring this conference with us.
Thank you, Jonathan. The Federalist Society is very proud to be a co-sponsor of today's conference, and let me welcome you all here today. Thanks for being here. We, the Federalist Society, are in the midst of our 25th anniversary, which means that since 1982, we have been dedicated to reforming the legal order, committed to the principles that I think are not very controversial at all, that the Federalist Society exists to preserve freedom, and that the separation of powers, governmental powers, is central to the preservation of that freedom and to the Constitution. And finally, that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Federalist Society provides forums like the forum today of legal experts of opposing views to interact with members of the judiciary, members of academia, other law students and academics and architects of public policy to further this discussion of our principles. And much of the programming and scholarship of the Federalist Society is produced by its 15 practice groups. These 15 practice groups that I'm director of, as Jonathan mentioned, are organized around different substantive legal areas, ranging from administrative law to free speech to religious liberties and to corporations and securities. And I want to talk just very briefly about some new initiatives or projects going on at the Federalist Society. All of them involve our website, and I want to mention them in particular because we have a virtual audience today. First, virtually all of the Federalist Society's programming, especially that done by the practice groups, is available online now, either as video or audio or both. Second, we are involved in a series of podcasts that we have developed These tend to be much shorter oral presentations of about 5 to 15 minutes in length. Last term, we did them as significant Supreme Court cases were decided, and this term, we're doing them as cases are decided, but we're also doing them as the most significant cases are argued. So I urge you to go to our website and check out those podcasts. As I mentioned, they tend to be much more digestible than our programming. They're 5 to 15 minutes in length. And finally, online, on the front page of the Federalist Society's website, we have a series of online written debates that are available for your viewing. They tend to be focused on what we think are the most important and interesting single legal issue emerging in the day. We just took down an online debate on the Parker D.C. handgun ban case, and we're putting up a new one on some legislation that's running through Congress at the moment. So I urge you to check all of those new aspects out. And let me conclude by thanking Case Law School and the Center for Business Law and Regulation for hosting this event today and for providing our venue in person and on the internet. Let me single out Jonathan Adler for special thanks in his work in getting the panels just right, recommending the right speakers, getting the right speakers, and letting the Federalist Society participate in a way that stays true to the Federalist Society formula about debate. And finally, let me just welcome you once again and thank the audience for being here. Jonathan.
Thank you, Dean. I want to leave most of the substantive discussion to our speakers and panelists today because they certainly know a lot more about this subject than I do. But let me say a little bit about the case and just a few housekeeping matters. As I already mentioned, Stoneridge case, Stoneridge Investment Partners versus Scientific Atlanta has been characterized as the most important securities law case to reach the Supreme Court in at least a decade. In 1994, the Supreme Court held that there is no aider and abetter liability under the Securities Act, but there have been remaining questions about whether or not third parties can be liable in securities litigation. And lower courts, administration officials, and academics have been quite divided on when, if ever, such liability should be available. In this case, in Stoneridge, the Eighth Circuit held that Motorola and Scientific Atlanta should not be liable to the shareholders of Charter Communications for their participation in allegedly fraudulent transactions that may have deceived Charter Communications shareholders about the financial health of the company. In other cases, for example, in the Ninth Circuit, the courts came out the other way. This case has implications not simply for the shareholders of Charter Communications, but as we will hear today, it has implications for who, if anybody, can be held liable, or which, if any, third parties can be held liable in some of the more prominent securities fraud controversies today. I'm sure, for example, we will hear quite a bit today about the implications of this case and what the court does for continuing litigation related to Enron. The structure of our program today is our first panel is going to focus primarily on some of the legal issues related to this case and underlying this case. We will then have a panel talking about some of the policy issues, whether or not we should view this as a case about American competitiveness or whether or not we should view this as a case about protecting investors and consumers and what some of the policy implications of this case are. And then at the noon hour, we will be, as a preview of the actual oral argument, we will be having a debate on the merits of the case itself. I think that with all of our panels, we will see quite a exchange and diversity of views, and you are part of that, both those of you here and those of you that are viewing online. For the first time with this program, we are enabling folks that are viewing the webcast to submit questions for the program. To do so, and the moderators will remind you of this, send an email to CaseCBLR, Center for Business Law and Regulation, @gmail.com. Again, that is CaseCBLR@gmail.com. And if you have questions for the panels in real time, and we will get some of those questions asked during the program. I also just want to say before I forget, and I will probably say this again, I want to not only thank Dean Reuter and the Federalist Society for co-sponsoring this event, but also want to thank all the folks here at CASE that have been so helpful in making sure this program was able to come together. As some of you know, I've been somewhat absent the past few weeks for a variety of reasons, And this program could not have come together without the able assistance of Al Simon, Nancy Pratt, James Wycamp, certainly all of our AV staff that make the webcast and all the internet aspects of this program possible, and certainly all of the speakers and all of you for being here. Without any further ado, I want us to get into our program. Larry Obhoff will be moderating our first program. He is an associate with Kirkland & Ellis in Chicago. Typically, his practice focuses primarily on civil litigation. He also is an adjunct faculty member here at the law school, where he has taught civil procedure. He'll be moderating our first panel, and then we'll introduce our initial speakers. Thank you very much.
The members for our first panel are Professor Barbara Black, Professor J. Robert Brown, and Professor Richard W. Painter. Professor Black is director of the Corporate Law Center at the University of Cincinnati Law School. Prior to this, Professor Black was a professor at Pace University School of Law, where she taught corporate and securities law. She was also the founder and co-director of the Securities Arbitration Clinic and co-director of the Pace Investor Rights Project. Professor Black's extensive professional experience includes being a visiting professor at a number of universities, including the University of Illinois Law School, Vytautas Magnus University School of Law in Lithuania, and New York Law School. She has also served as Deputy Director of the Association of American Law Schools, as well as Vice Dean and Acting Dean at Pace University Law School. Professor Black is a prolific writer, and she has authored numerous articles on securities arbitration, securities fraud, and RICO claims. She is frequently cited, including being cited for her publications on fraud on the market in both the majority and the dissenting opinions in the Supreme Court case Basic v. Levinson. Our second panelist, J. Robert Brown, has been teaching corporate and securities law at the University of Denver Sturm College of Law for almost 2 decades, with his particular emphasis on corporate governance. He has authored numerous books and articles on the subject and has been cited several times by the United States Supreme Court, including also being cited in the Supreme Court case Basic v. Levinson. Professor Brown has spent significant time in corporate governance matters abroad, including time in Russia, Armenia, Kazakhstan, and the West Bank. From 2000 to 2004, he served as Associate Dean for Academic Affairs at the Sturm College of Law. He is an arbitrator for the NSAD, a sponsor and active contributor to a corporate governance blog, The Race to the Bottom, which you can find at www.racetothebottom.com, and serves as chairman of the board of directors of the Colorado Coalition for the Homeless. Professor Painter received his B.A. summa cum laude in history from Harvard University and his J.D. from Yale University, where he was an editor of the Yale Journal on Regulation. Following law school, Professor Painter clerked for Judge John Noonan of the U.S. Court of Appeals for the Ninth Circuit, and he practiced at Sullivan and Cromwell in New York City. From February 2005 to July 2007, he was associate counsel to the President in the White House Counsel's Office. Professor Painter has been active in law reform efforts aimed at deterring securities fraud, and a key provision of the Sarbanes-Oxley Act of 2002 was based in part on law review articles that he wrote. He has lectured widely on the Sarbanes-Oxley Act and has testified before the U.S. House of Representatives and the U.S. Senate Committee on Privacy, Securities Litigation, and the Role of Attorneys in Corporate Governance. Professor Painter is the author of 2 case books, one on securities litigation and enforcement, and one on the professional and personal responsibilities of the lawyer. More detailed descriptions of the panelists can be found in the program with today's event. As mentioned by Professor Adler, we will be taking questions after the panelists are done speaking, and we will be taking questions online that can be submitted to the email address casecblr@gmail.com. Thank you.
Thanks, Larry. And thanks, Jonathan, for putting together this program. I've been asked to speak a few words about central bank, which, as Jonathan mentioned, is the case in which the Supreme Court held there was no aiding and abetting liability under Rule 10b-5. That was a 5-4 decision. I'll talk more about that later. I want to lay out the allegations in Central Bank because I think it'll provide a useful comparison later when Jay talks about Stoneridge. A municipal bank building authority issued bonds to finance public improvements at a development. The bonds were secured by liens on the property, and the bond covenants required that the land be worth at least 160% of the bond's outstanding principal and interest, and that the developer provide an annual report to the indenture trustee to that effect. The bonds were issued in 2 issuances. 6 months before the second issuance of bonds, Central Bank of Denver, which was the indenture trustee, had concerns that the 160% test was not being met. It considered obtaining an independent appraisal, which it was permitted to do. It was not required to do that. It decided ultimately, however, that it would postpone that appraisal until year end. Thereafter, about 6 months after that, the second issuance of bonds went out. Before the bank got around to doing that independent appraisal, the authority had defaulted on the bonds, and the lawsuit ensued. The complaint alleged that the bank, the indenture trustee, was secondarily liable under Section 10b and Rule 10b-5 in aiding and abetting the securities fraud. The Second Circuit, in conformity with other circuits, held that the bank could be held liable on an aiding and abetting theory. It remanded the case for various fact findings on the question of recklessness and the question of substantial assistance. And it then went up to the Supreme Court, and the Supreme Court, again, reversed the 10th Circuit and held 5-4. There's no aiding and abetting. All right. Now, the legal analysis, like most recent securities court's opinions interpreting Rule 10b-5, the court looks primarily at the statute. Its primary approach is plain meaning. It picks up the statute and it reads it, and the majority held that 10b and Rule 10b-5 liability did not extend to aiding and abetting. The statute prohibits use of employment of any manipulative or deceptive device or contrivance. The majority said that language does not include giving aid to someone who uses a manipulative or deceptive device and contrivance. The majority also found this result was consistent with the express remedies in the federal securities laws, none of which expressly provide for aiding and abetting. In addition, the court went on to discuss some policy considerations that were raised by the SEC in support of aiding and abetting, although the Supreme Court made clear that the policy considerations were of significantly less importance to it. The majority specifically raised the concern that secondary liability exacts costs that may disserve the goals of fair dealing and efficiency in the securities markets. The rules for determining aiding and abetting are unclear in an area that demands certainty and predictability and may lead to vexatious litigation that can lead to settlement of even frivolous claims. In concluding the legal analysis, I want to quote from 2 sections of the opinion that are frequently cited in this debate over scheme liability, one of which is a sentence the majority said, as in earlier cases considering conduct prohibited by Section 10b, we again conclude that the statute prohibits only the making of a material misstatement or omission or commission of a manipulative act. That's language that, as Jay will tell us later, the Eighth Circuit emphasized in its Stoneridge opinion. The other quote that is cited in this debate is a bit longer, but I'm going to read it in its entirety. The majority stated, the absence of Section 10b aiding and abetting liability does not mean that secondary actors in the securities markets are always free from liability under the Securities Acts. Any person who employs a manipulative device or makes a material misstatement or omission on which the purchaser or seller of securities relies may be liable as a primary violator under Rule 10b-5, assuming all of the requirements for primary liability under Rule 10b-5 are met. In any complex securities fraud, moreover, there are likely to be multiple violators. As we consider later on the relevance of that language, I think we should keep in mind that central bank was a material misrepresentations case. That was the allegation in that case. So there was no reason for the court to be focusing on other kinds of conduct. There was a dissent. 4 justices dissented, emphasizing that 11 courts of appeals had recognized a private cause of action for aiding and abetting, and felt that that was a settled construction of an important legal statute that should not be disturbed unless and until Congress decided otherwise. So that's central bank. Briefly, a few post-central bank developments. After central bank, Congress amended the Securities Exchange Act to allow the SEC to bring aiding and abetting actions, but Congress declined to extend the right to private parties, citing concerns about abusive securities fraud litigation. Post-central bank, the lower courts have been struggling with this distinction between primary and secondary liability. And I just want to briefly mention a couple of significant cases in this area. One dealt with material misstatements. The Second Circuit picked up on central bank's emphasis on the reliance element and announced a bright-line test. A secondary actor could not be liable unless the misstatement was attributed to him at the time of the misstatement. In contrast to that, the Ninth Circuit has a substantial participation test, which many have criticized as being aiding and abetting in another form. In the area of manipulative conduct, the Second Circuit has held that a broker who followed the directions of a stock promoter and executed trades to further the promoter's manipulative scheme could be primarily liable for stock manipulation, so long as he knew or was reckless in not knowing that the trades were manipulative, even if he did not share the promoter's specific purpose to manipulate the market. The Second Circuit said the distinction in this case was that it was manipulative conduct that was alleged. Now, I mentioned that this was a 5-4 split. Of those justices who participated in central bank and are still on the court, there are 3 on each side. Majority on central bank was Justice Kennedy, who wrote the opinion, and Justices Scalia and Thomas. On the minority were Justices Stevens, Souter, and Ginsburg. Judge Breyer has recused himself from the Supreme Court proceedings. So with that, I will turn it over to Jay.
Thank you, Barbara. Let me emphasize 2 points I think that bear repeating about central bank. The first thing is central bank did, of course, I think, set the tone for how this issue needs to be resolved, and that is you have to look to the language of the statute itself, and that language is this language that says deceptive devices are essentially prohibited or are fraud. Now, what's interesting, though, about central bank, in concluding that there's no aiding and abetting liability, central bank didn't really interpret the language of Section 10b. What it did was it interpreted the absence of language in Section 10b. The court really emphasized that if Congress had intended aiding and abetting liability to be prohibited, it would have said so. And what it really said was the words aiding and abetting don't appear anywhere in the statute. So we know a lot about what's not in 10b from central bank. We don't know a lot about what is there. The court didn't give us much help on that. A little bit, but not a lot. The other thing is, when you go back and look at the role central bank played, central bank was a indentured trustee in this fact pattern. But here's an interesting thing. The court never analyzed central bank's behavior for purposes of whether it was truly secondarily liable or primarily liable. If you read the end of the opinion, Kennedy says, look, the parties characterized central bank as secondarily liable, as aiding and abetting, and we accept their characterization, and therefore we have to dismiss this case in central bank because of the way the plaintiffs characterized it. In other words, the plaintiffs could have tried to characterize Central Bank as a primary violator but didn't. So as a result of that, we don't really know what facts in Central Bank were important to the court in determining what's secondary liability, what's primary liability. So in my opinion, for those that argue that Central Bank sort of resolves this issue, I think we have more uncertainty from Central Bank than we have certainty with respect to this issue. Now, in the aftermath of Central Bank, the courts had to wrestle initially, I think, with a class of participants that I would describe as those involved in the disclosure process but not really making the disclosure. These securities fraud suits are always about fraud or securities misstatements committed by the company. But when the company makes a false statement, you have others involved in the process. For one thing, you have officers and directors. They're not making the statement, but they're involved in the process. For another, you have accounting firms. They're not usually making the statement, but they're involved in the process. So the courts had to wrestle with other actors involved in the disclosure process. And in general, while Barbara gave a good rundown of this, and it involves multiple tests and it's complicated, in general what the courts have said here is involvement alone is not enough. That's not enough to establish primary liability. You have to do something more than that, and you either have to make your own false disclosure or you have to be so involved in the process that sort of presumptively the disclosure can be attributed back to you. The vendor cases, which is Stoneridge, are very different. They're very different. These are actors that have nothing to do with the disclosure process itself. They're not involved in drafting. They're not involved in determining what goes into the disclosure. They're not reviewing the company's financial statements. There's no allegations of any of that with respect to the vendors in Stoneridge. Instead, what they're doing is engaging in a course of conduct, in behavior, in actions, and it's those actions that the company then takes and uses to commit its own securities fraud. So what the courts have had to wrestle with in Stoneridge, the case before the Supreme Court, and in a series of other cases sort of around it is, when are those that are not in the disclosure process but provide the company with the facts that it needs or the circumstances that it needs to commit securities fraud, when will they be liable? Very different. So the first case in this area, I'm not going to go through them all, but I just want to mention it, is Simpson versus AOL Time Warner. And in that case, Homestore.com engaged in transactions with various vendors buying services, buying products, and what according to the allegations in the complaint and in the opinion, what Homestore.com got was an agreement from the vendors to return the money to Homestore.com in the form of these so-called advertising contracts. So they would get paid a certain amount of money for services. They would then remit the money back, the same amount of money in the form of these advertising contracts. And plaintiffs in AOL Time Warner argued these were sham transactions, and it was because of these sham transactions that the company was able to then go and commit securities fraud. Now, there's two things very interesting in that case for purposes of Stoneridge. One is that the SEC filed an amicus brief in that case. And the reason why that's so important is the SEC did not file an amicus brief in Stoneridge. Now, given that there are probably 100 parties represented one way or another through various amicus briefs in Stoneridge, you have to ask yourself the question, why isn't one of them the Securities and Exchange Commission, the entity in the United States that's responsible for overseeing the securities markets? And the answer to that is that the SEC has the authority to enter into district court cases and to the Court of Appeals cases directly, but it has no authority to enter into Supreme Court cases directly. Instead, it has to go through the Office of the Solicitor General in the executive branch. And according to published reports, the SEC voted 3-2 to ask the Solicitor General to file a brief on its behalf in Stoneridge, and by virtue of the fact that none was filed, we can surmise that the answer from the Solicitor General was no. And in fact, the Solicitor General filed a brief, but on the other side of the case. So the SEC is not in Stoneridge, but the SEC is in Simpson versus AOL Time Warner. And the SEC in its amicus brief in Time Warner said, in fact, that the securities laws, that 10b and 10b-5, ought to apply to actors because of their actions and behavior. In other words, it ought to apply, at least in some instances, to the vendors. And one of the sort of interesting little notes in that brief that I just wanted to point out, there are a lot of things, and you should take a look at the brief. It's a well done, I think, job. And that was one of the reasons the SEC gave for extending liability to vendors is the SEC said actions and disclosure can come out in the same place. They can commit the same offense. And they gave in the brief an example. What if an investment banking firm had a client and described that client as having sound credit? And it turned out that was false. Well, the investment banking firm could be sued for that because the investment banking firm made a disclosure and it was false disclosure. What if, on the other hand, that same investment banking firm had a client and what that investment banking firm did was engaged in a series of sham transactions that allowed that client to hide all kinds of debt from the public? In other words, that client would then project an image of having sound credit. And the SEC said in its brief that these two actions, one disclosure, one behavior or actions, they achieved the same deception. They achieved the same deception. So from the SEC's perspective, I think, the SEC said that there was no reason to exempt actions or behavior from Section 10b or 10b-5. The Ninth Circuit ultimately adopted a test known as the purpose and effect test, and that test said that vendors, so the Ninth Circuit had to decide, though, when are vendors liable and when are they not. All vendors engage in transactions. All transactions could potentially be used by the company to commit some kind of false disclosure. And the Ninth Circuit decided that it was any vendor who entered into a transaction where the principal purpose of that transaction was to have the effect of causing false disclosure. So you had to have as a purpose not to enter into a contract for business purposes, but it had to have the primary purpose and effect of causing false disclosure. Now, Stoneridge. So we come up to Stoneridge. In some ways, Stoneridge sounds a little bit like AOL Time Warner, because what happened in Stoneridge, according to the allegations in the complaint, was that Charter Communications needed to improve its financial performance or the appearance of financial performance, and it went to a couple of its vendors. These vendors sold Charter black boxes. You know, they're the things that connect your cable hookup in your house. I was looking at mine just before I came out here, my little black box, and it's from one of the vendors that are in this case. And so what happened was, according to the complaint, was that Charter had an agreement with these vendors to buy these boxes at a fixed price. Charter went to them and said, hey, I know we only have to pay X, but how about if we buy a whole bunch of these boxes from you instead of X at X plus $20? We'll overpay by $20. Well, it sounds like a good deal if you're a vendor. Charter then got the vendors to agree, though, to return the $20 in the form of advertising contracts. So the vendors would take that $20, buy advertising from Charter, and Charter would essentially get the $20 back. And in the complaint, the plaintiffs alleged that these were sham transactions, and they alleged also that the vendors knew what Charter was going to do with this information. So that's sort of the facts that the Eighth Circuit got. Now, how did the Eighth Circuit distinguish between some vendors, these vendors that enter into perhaps legitimate transactions that are mischaracterized by the issuer or the company, and vendors that engage in something like sham transactions? And the answer from the Eighth Circuit's perspective, the way they distinguished it, was to say vendors are never liable, effectively. And what the court said in that case was deception, which is necessary for 10b liability, deception does not occur absent some misstatement or failure to disclose by one who has a duty to disclose. In other words, a vendor couldn't be liable unless they made false disclosure themselves or they had a duty to make disclosure. So it didn't matter what else the vendor did. There had to be some sort of disclosure problem with the vendor's behavior. Now, I will add here that the Eighth Circuit mostly relied on some Supreme Court cases. This particular quote, they cite Santa Fe, but in the brief filed by the Solicitor General's office, the Solicitor General office said there is no support in the Supreme Court cases for this position. If I were going to give this as a fact pattern on one of my exams, I would complicate the facts a little bit. I'd say, okay, so assume it's a sham transaction, and assume that these boxes there was an overpayment of $20 and that there was some obligation, that there was already a contractual obligation to buy these boxes at the lower price. But let me make the facts harder, I'd do, if I were giving this exam hypothetical. I'd say, assume that the vendors provided documentation about these transactions that was false. And further assume that the vendors entered into these contracts, but the contracts were backdated, and that backdating was necessary for Charter to, or the company to achieve the necessary accounting treatment that it wanted to achieve. Then, when you have sham transactions, falsified documents, backdating, and the falsified documents and backdating, of course, have the effect of making it harder, if not impossible, for the outside auditors and accounting firms to learn the truth of these transactions. I would then say to my students, is that something that you would like to exonerate? Well, in fact, those are the facts in Charter, because what happened was, while the Eighth Circuit relied on the amended complaint, the plaintiffs filed a second amended complaint, and the court did not allow it to be filed. And in the second amended complaint, it had a lot more facts. And the facts came from the fact that Charter settled. And Charter gave a lot of information to the plaintiffs. And among other things that Charter apparently disclosed was that the vendor, one of the vendors, sent a letter to Charter saying the reason for the increase in the price was due to increased manufacturing costs. And as the plaintiffs say in their complaint, the vendor did that knowing it was a lie. In other words, it wasn't because of an increase in cost, it was because Charter asked them to do it. The second thing was the contracts were executed in September, but they were backdated to August in order to make it seem like there was more distance between the purchase of the boxes and the advertising contracts. If they were too close in time, they couldn't have been treated the way that Charter wanted to treat it. So we have a nicely teed up exam question, and we have a nicely teed up case for the U.S. Supreme Court, which is, when can a vendor be liable? When a vendor engages in a sham transaction, falsifies documents, backdates contracts, and that information is then used by the issuer to commit securities fraud. So we'll see essentially how the court comes out on this and whether behavior is ever enough to constitute securities fraud. Let me just end with two quick observations. One observation is that this case certainly returns to the forefront the issue of whether the Securities and Exchange Commission should have its own independent authority to file a brief in the U.S. Supreme Court, having been denied that by the Solicitor General's office. The SEC is an independent agency. The Federal Trade Commission has its own independent authority to file a brief when the Solicitor General says no, so otherwise they usually go through the Solicitor General's office, but if the Solicitor General says no, the FTC can do it. There's some issue here as to whether these complicated securities cases ought to have the voice of the SEC when the Supreme Court makes its decision. The second thing is that, you know, this case was moving along merrily as a question of is behavior or actions ever enough to establish deceptive behavior. And I have to say that the U.S., the Solicitor General's office, which again sided with the Eighth Circuit and sided with the respondents in this case, in other words, wanting the Supreme Court to affirm the Eighth Circuit's decision, really just came out with kind of a surprising position. And in that amicus brief that was filed by the Solicitor General's office, the Solicitor General wrote this: the Court of Appeals in this case erred to the extent it held that Section 10b reaches only misstatements, omissions made while under a duty to disclose, or manipulative trading practices. The plain language of Section 10b demonstrates that it potentially reaches all conduct that is manipulative or deceptive. I think this brief makes it very hard for the U.S. Supreme Court to affirm the Eighth Circuit's decision on the basis used by the Eighth Circuit. Thanks.
Well, we're talking about fraud here, so I just want to get back to common law fraud and what's actionable, what is not. I buy a car, a used car, and the odometer is set at 20,000 miles, and it turns out that that odometer has been tinkered with, and it really was 100,000 miles before the owner took it into the repair shop to be fixed. Who can I sue? Can I sue the owner who sold it to me, who lied to me for fraud? Yes. Should I be able to sue as an aider and abettor in that fraud the repair shop if the repair shop knowingly set the odometer back and indeed had a little business where they were doing this for car owners who wanted to sell their cars on the used car market? Should I be able to sue the repair shop in that situation for this manipulative device or contrivance, if you might call it that they have installed or manipulated in the car? I would think the answer at least should be yes, and in many courts would be yes, if they knowingly did that. Now, let's set aside the recklessness issue. But if they knowingly participated in the fraud, even though they didn't make the representation to me that the car had only 20,000 miles on it, they knew what they were doing. And a repairman, of course, you would think ought to know, when someone's asking them to horse around with the odometer, what's going on. So you would argue perhaps even reckless conduct there ought to be actionable. But let's draw the line at knowing conduct and say that in many courts you would be able to assert some form of fraud complaint against the person who did that. Well, how about securities fraud? Well, securities fraud was treated like common law fraud in many jurisdictions under state law before the 1933 and the 1934 Acts. Congress got in there in 33, 34, decided there would be federal law governing the sale of securities in the 1933 Act and purchases and sales and various other aspects of the securities markets in the 1934 Act. Congress knew how to enact express private rights of action. It did so in various parts of the 33 Act and the 34 Act. Points to Section 11 of the 33 Act, Section 12 of the 33 Act in particular. And Section 10b of the 1934 Act does not have an express private right of action. There is little support for the argument that Congress intended for there to be a private right of action under Section 10b. What Congress did do is leave state law intact. The right to sue under state blue sky laws, under state common law fraud theories, intact. Well, what happened in the 50s and 60s into the 70s? We've had courts that decided they would imply private rights of action under various provisions of the 34 Act in particular, where the private right of action would further the purpose of the Act. The courts did this under Section 10b in connection with manipulative or deceptive devices in connection with the purchase or sale of securities. The courts did this under Section 14a in connection with proxy, defective proxy solicitation materials. The courts decided that there would be implied private rights of action under those provisions, even though Congress never articulated that intent to begin with. Well, this is where the mischief starts, even though I have very strong sympathies with the underlying policy that the court was seeking to impose, the courts, through doing this. The question is who should be doing it, Congress or the courts? And what we then have is more conservative courts in the 70s, 80s, all the way on through today, starting to backtrack on this path toward implied private rights of action. But they don't like to overrule previous cases, or like to do that very rarely. So they start chipping away at it, and sometimes in illogical ways. And I would suggest that Central Bank of Denver is perhaps one of those illogical ways. And as Professor Brown has pointed out, the Central Bank of Denver case leaves a lot of lack of clarity rather than drawing particularly bright lines. Who is a primary violator versus a secondary violator? The aider and abettor is not liable, but the primary violator is. Well, then how does someone fall into one category or another? And then we have dozens of cases trying to sort this out, and of course law review articles, law professors and law review articles rushing to the rescue with no one coming up with a particularly coherent answer. Well, what goes on then is Congress in 1995 says the plaintiffs are out of control in these suits under Section 10b and various other provisions of the securities laws, and we need to tighten up, and they tighten up mostly on procedural aspects of securities litigation with very few substantive revisions to the law, but we see higher pleading standards and a number of other changes to the 1995 Private Securities Litigation Reform Act. One of the interesting things Congress did do is decide that the SEC ought to have the right to go after aiders and abettors. In other words, the Central Bank of Denver case should not be, Congress believed, interpreted to let aiders and abettors off the hook, the financial equivalent of the car repair shop that intentionally sets back the odometer on the car. Someone ought to be able to go after them, and that shall be the SEC. It seemed quite clear that Congress, they could have overruled Central Bank legislatively, and they did not. So what we see that's quite interesting all along the way here is Congress basically acquiescing in what the courts have been doing. First, in creating the implied private right of action, Congress does not expressly go back and say, no, in 1934 we never intended that, and we don't intend it now. There shall be no private right of action under Section 10b. But Congress will not do that, and yet Congress, on the other hand, is not going to step in and expand the private right of action to legislatively overrule Central Bank of Denver. They just sort of let the courts go ahead and get deeper and deeper into this judicial morass. I see these cases quickly becoming. Well, then Congress, of course, makes things even worse in 1998, and I testified against this before the House and the Senate. They say, this federal law is so good, right, that we're going to preempt all of state law. Well, not all of state law, but class actions brought for securities fraud in state court. Class actions in state court or in federal court under state law shall be preempted. So now that which Congress had left intact, because Congress in 1934 did not create this express private right of action, understood that the states would have the ability to take care of it. Congress explicitly said the states could take care of it, and left the state law intact here, that at least with respect to class actions for securities fraud, the equivalent of Section 10b, those are preempted. They must be in federal court, so that's where you have to go if you have one of these class actions, and you have to deal with this wonderful case law that we have. Well, now we are confronted with a situation where the Supreme Court is being asked to distinguish central bank. So central bank distinguishes between aiders and abettors and primary violators. That's confusing enough. And now if we are to distinguish between one group of aiders and abettors and conspirators and say, well, conspirators shall be liable, but aiders and abettors shall not, well, that's going to create a very interesting set of distinctions that could, of course, generate about 24 more law review articles and more lower court opinions trying to sort it all out. I think it's going to be very hard for the Supreme Court to do that, to not overturn central bank, a decision that I've never particularly admired, and yet fine for the plaintiffs in this case. But perhaps they can come up with a way of doing that. And leave us with the task of trying to interpret it. Well, where should we go from here? And I'm going to assume, I think, that the Supreme Court's going to find for the defendants in this case under central bank, but we shall see. One is to return to state law here and reinvigorate state law and allow people to sue for securities fraud, including suing aiders and abettors in class actions in state court. There's no reason this necessarily has to take place under federal law, and I think Congress understood that in 1934 and repealed the 1998 Securities Litigation Uniform Standards Act that preempted state class actions. The second place we could go is strengthen SEC enforcement authority. And I think this is very different than criminal prosecutions. Criminal prosecutions have posed all sorts of problems and abuse of prosecutorial discretion and so forth when these things end up in the hands of the U.S. attorneys. And that's not necessarily an area that I would like to see more activity rather than less. But the Securities Exchange Commission certainly could step up its efforts with respect to going after aiders and abettors. Congress sent them the very clear message in 1995 that they could do this, go after the aiders and abettors and the co-conspirators, and the SEC should do this. And in appropriate situations, yes, refer the matter to the U.S. attorneys. And then finally, we could think about having a coherent, I emphasize coherent, federal private right of action for securities fraud coming from Congress, not from the courts, where Congress could revisit a lot of these issues, including the liability scheme, who shall be liable. And I do not think it makes a great deal of sense to distinguish between the aiders and abettors and the primary violators, at least for knowing violations. I think recklessness is perhaps a different question. If you're not talking about the person who actually spoke to the investors, you're talking about somebody else, a person who worked on the contracts that were misleading and so forth. It, to me, might make sense to draw the line at knowing conduct, but someone who knowingly backdates a contract, someone who knowingly writes that letter saying that the reason they're doing this is increased costs or whatever, when that's a lie, someone who knowingly lies, knows it's going to be used in connection with the purchase or sale of a security, that person ought to be part of the group of people that ought to be subject to civil liability in a coherent private right of action for securities fraud. But I think that ought to come out of Congress, not the courts. And Congress, meanwhile, needs to think about why has there been so much hostility to the private right of action for securities fraud. We know about the conduct of some plaintiffs' lawyers in this area. A few were headed off to the Club Fed for a stint for apparently passing kickbacks back to their lead plaintiffs. That doesn't do well for the plaintiffs' bar, but there are many, many plaintiffs' lawyers with a very high degree of integrity in this business, and there is a need for private plaintiffs to have a right against those who knowingly participate in securities fraud. But Congress should perhaps think about how to weed out the abusive litigation. Did the 1995 Private Securities Litigation Reform Act, did they do enough there? Should they think about fee shifting? The English rule, if you sue, you lose, you pay the other side's attorney fees. I know that's very unpopular in the United States, and I would not suggest necessarily that the private plaintiffs who sue and lose ought to pay. But perhaps their lawyers ought to think about it, particularly the lawyers who are bringing repeat cases. Should a law firm at least have to, out of their winnings on the cases they win, contribute something to the attorney's fees of people who they have sued unsuccessfully? Should these firms like, well, Melberg Weiss was certainly in there for a while. They're, I guess, not in the business anymore. But other firms will step in and conduct this litigation. And should plaintiffs' firms have to offset, at least against their winnings in the winning cases, something to help with the attorney's fees in those cases that were not successful. And that might help weed out some of the frivolous cases, restore the public confidence in the litigation system so we can hold aiders and abettors who knowingly commit securities fraud liable under the federal securities laws. Thank you.
As mentioned at the outset, if anybody is watching this on the webcast right now, we will be taking questions at the email address casecblr@gmail.com. And before I begin with the questions, I think I owe an apology to Professor Brown. His website is actually www.theracetothebottom.org. I think I referred to it as .com earlier. It's a great website. Everyone watching at home and everyone here today should definitely check it out. Do we have any questions presently? Okay. Professor Adler.
In a piece in the Legal Times, attorneys Gregory Markell and Gregory Ballard, who definitely would side with the defendants in this case, argued that fairness and an efficient economy demand a clearer description of the standard of conduct that third parties, and particularly financial institutions, must meet. In a response to that article by William Lurack and Thomas Wilhelm, two attorneys that filed a brief supporting plaintiffs in this case, say they completely agree with that. So there seems to be agreement that we need a clear standard of liability for parties, third parties, and financial institutions. And my question for all the panelists is there an easy way in this case, given the precedent and the law, for the court to do that, to give a clear standard of liability, but that at the same time doesn't let off the hook folks that at least most people would think need to be at least potentially liable for certain types of fraudulent actions?
You know, I sometimes think the clarity argument is kind of something you use when you don't have a lot else to use. In BASIC, the case Barbara and I were both cited in, it's established a standard for materiality that said what would be important to a reasonable investor. I mean, talk about something that's an amorphous standard. So it's not as if clarity runs all through this as a necessary precondition. But, you know, when you look at the briefs that the petitioners filed in this case, the petitioners seeking to have this case overturned, to get the Eighth Circuit overturned, they didn't argue for a particular test, although there's this purpose effect test from the Ninth Circuit. They didn't argue for it. What they said was this: isn't it enough that we have allegations of fraudulent documents, backdating, and sham transactions? And what they said to the Supreme Court was, just say that's enough and send it back. So, you know, one way you get clarity in this case, it's not to say there aren't really hard issues about where to draw the line, but at least in this case, you have what at least has been pled as pretty egregious behavior, and I don't think you need to have I don't think you need to make this the hard case. I think the facts in this case are relatively stark.
Yeah, and I think, you know, again, since the Supreme Court takes us back to the statute, you've got a statute that says deceptive conduct. That weeds out a lot of things right there, particularly with a high standard of scienter. I think that's pretty clear, actually, as clear as you can get when you got complicated facts and all as, you know, with all the permeations. I mean, if they were as simple as the odometer case, life would be simple, but it's not. Fraud is complicated.
Well, I think central bank is a very unclear case. It's created a lot of ambiguity. They could overrule central bank. They're not going to do that. They're going to have a tough time coming up with a clear rule on this one. You know, they find for the defendants, and they basically just expand central bank, but probably in a direction that's predictable. They find for the plaintiffs, and it's going to be a very interesting situation. The way to clarify this is for Congress to confront the issues and to stop ducking the definition of a private right of action under Section 10b. What shall it look like? Who can sue? Who cannot? This needs to be dealt with legislatively, and ever since Congress, they rejected Louis Laws's draft securities code back in the 70s. They don't want to deal with it. It's a political hot potato, and they want to just continue to let the courts dig themselves in on this, and I just don't see clarity coming from the courts.
I actually have a follow-up, Professor Black. You might want to answer this first. You referred to the statutory text, and part of the statutory text also says in connection with the purchase or sale of any security. And I was wondering how you would respond to some of the arguments made by various parties filing amicus briefs arguing that there would still be liability for things like mail fraud or wire fraud or common law fraud and possibly even perhaps racketeering predicates, and that maybe those statutes should be used instead of Section 10b.
Well, you know, the in-connection requirement's been interpreted pretty broadly. You know, you look at SEC against Sanford and some other Supreme Court cases, the Davitt case. You know, it's securities fraud when you've got misrepresentations that are being made for purposes of affecting the market price. It certainly can be other things as well, like mail fraud. But in my mind, that's not a good argument. I think there are some good arguments on the reliance and the causation issues, but I don't see strength in the in-connection with argument.
I think in this case, you know, there's a lot of disagreement, but there's a lot of agreement too. And I think one of the places where everyone is in agreement is that for vendors, it shouldn't be easy to reach them. The first thing is whatever test is adopted, the vendors also have to engage in all of the other elements that are necessary for a 10b-5 violation. That means the false disclosure that results from the conduct has to be material. It means that they have to know because of the scienter standard or possibly reckless, but at least they have to know. So they have to meet a very difficult test. And one thing that I think everybody makes clear, the Ninth Circuit, the SEC brief and Simpson, the parties, is that if there's a transaction that's a legitimate transaction by the vendor and the company uses that transaction to commit securities fraud, even where the vendor knows they're going to do it, that's not primary liability. That's aiding and abetting at most, maybe not even that. So we're not talking about nailing vendors because they know their transaction will be used to commit fraud. We're talking about, at least so far, at least if you look at the Ninth Circuit test, the test being where the vendor itself enters into the transaction primarily with the purpose of causing false disclosure. And that doesn't seem to me to be a very easy test to meet, and I frankly think that if that ends up being the test, we're not going to see that many vendor cases, except in cases where the issuer goes under, and so there's essentially no defendant to provide a recovery, so they're going to have to target a broader group of people. But I think most plaintiffs are not going to target vendors because they're going to be too hard to get, even under that test.
I agree with that.
Okay. Do we have any other questions? Professor Adler, do you have one from the internet?
I was interested in the points you were just making. I guess a question I'd have that no one's really addressed is the question of pleading, in the sense that it seems that you're right, that it may be difficult to reach the vendors, but it seems like in all of these cases as well, the case often, if not always, gets decided at the start. And it seems to me that it may be difficult to prove that there's been the vendors have actually engaged in that sort of conduct. But to actually plead it is another thing altogether. I'd be interested in the panel's response.
The pleading standards are extremely high since the 1995 Act, and particularly the way the courts have interpreted the 1995 Act. So that's yet one more reason for having comfort that if the court were to backtrack on central bank and bring some aiders and abettors within the ambit of liability, that you're not going to have an excessive number of frivolous suits out there that survive for very long. You have to plead at the beginning, before you're going to get a discovery, all of the elements of securities fraud and plead them successfully. And a lot of suits are going to get weeded out at that stage.
Yeah, you know, when you look at the briefs that were filed, the amicus briefs that were filed in Stoneridge, and if you look at the ones filed on the side of the defendants, there's a lot of emphasis put on the policy argument, you know, abusive litigation, excessive litigation, et cetera. And it seems to me that argument has to be updated to take into account the Reform Act. It is just a lot harder to do it these days, and the Act is serving its purpose of weeding out a lot of litigation.
This case is a classic example of how hard it's going to be on the plaintiffs. I mean, first of all, in the Ninth Circuit case, the one case that said it doesn't require disclosure, that actions can result in fraud, they dismissed the case. They affirmed the dismissal against the plaintiffs. The plaintiffs were unable to plead that the behavior was sufficient to meet the test. Look at this case. This case, the plaintiffs file a complaint, and you know, when you file a complaint in a securities class action lawsuit, because of the PSLRA, this law adopted in the 90s, there's a stay of discovery. So the plaintiffs can't get discovery. So all they can do in their complaint is whatever they can get from the public domain. They might try to get confidential informants and things like that, but it's only what they can get themselves. In this case, the amended complaint didn't have in there the allegations that one of the vendors sent a letter with that falsely described the purpose of this. It didn't have allegations in the first complaint that there was backdating. They only got that information because they settled with Charter, and Charter gave them that information. So they were able to file a second amended complaint that just maybe meets the standard. If they hadn't been lucky enough to get a settlement with one of the parties, I bet you that amended complaint would be a complaint that everyone would concede isn't sufficient, probably, to establish the necessary behavior. So it's a very high pleading standard, and it's very hard to get the kind of information that you need against the principal parties, against the company and the officers and directors, much less vendors. Most of the vendor cases, if they're brought at all, are going to get dismissed at the pleading stage.
Just want to say, I also teach lawyers ethics, and people have asked me what's the connection between that and securities law. And I think you see a lot, and it's the point I've made about the standards of integrity in the plaintiff's bar. There are a few, and it's relatively few lawyers, but very powerful lawyers who have not behaved themselves appropriately. And what we see is that plaintiffs' lawsuits then can be tarred with the image that they are frivolous and brought with dishonest purposes. We see that tone in many of the opinions of the court. I think Justice Rehnquist and Blue Chip Stamps and some others, where there is clear hostility to frivolous litigation. We see that in the defense briefs here. We see that in Congress in the 1995 and 98 Acts. And that substantive rights of plaintiffs are being impacted here through unethical conduct on the part of some, by no means all, elements of the plaintiff's bar. And that issue needs to be grappled with by the bar as well as perhaps by Congress, because what we're seeing, as I say, is a deterioration of plaintiffs' protection and investor protection as a result of it.
Professor Adler, did you have?
Just as a follow-up to that, there's talking a lot about future vendor cases, but what about the other sorts of cases that are at least potentially implicated? Certainly, this case has implications for the continuing Enron litigation. There's lots of, certainly in the press, discussions of what this means for Enron's bankers. There's even a brief filed in this case by several prominent transactional lawyers arguing that finding liability in this case could create potential liability concerns for lawyers and their ability to represent clients who engage in business with issuers. Should we see these categories of potential defendants as separate from vendors like Scientific Land and Motorola? Are they of a piece? Are these sorts of cases more or less likely? I mean, I'm just wondering if panelists could unpack a little bit the potential liability for other sorts of parties that might be subject to this sort of suit.
Lawyers, that's the part of it I've worked on, and to some extent you wonder if they're crying wolf here. We've been through this before when the movement was afoot to require the lawyer just simply under ethics rules to report up to the full board of directors of their own client known corporate fraud. The American Bar Association resisted proposal to change its own rules and then lobbied strenuously in Congress against the federal provision that does precisely that, Section 307 of the Sarbanes-Oxley Act, and of course there being no civil liability attaching in that circumstance. The parade of horrors that would follow if a lawyer actually had to tell their own client's board of directors when the officers are committing fraud. Well, now the concern is, could I be sued if I knowingly participate in securities fraud? I don't think that good lawyers ought to have that much to worry about here. I think the reckless standard gives some ambiguity there and might raise some interesting questions. But if you apply this to people who knowingly commit securities fraud and who aid and abet, and as I say, I think you've got to go back and revisit Central Bank if you're really going to go after co-conspirators here, co-conspirators, aiders and abettors, people knowingly do it. Is that really going to impact the ability of a lawyer to give sound legal advice? The fact they could be sued for knowingly participating in securities fraud, I doubt it.
One of the briefs for the respondent said, well, come on, sometimes it's okay to backdate contracts, which is true. But I think that in this case, that the brief that was written by counsel, but it had 5 attorneys from New York, well-known attorneys that everybody here has heard of, was a very powerful brief. It was a good brief. I mean, always there are these interpretive issues, and the fundamental question was, we securities lawyers don't really necessarily advise these clients on their contracts that involve the sale of black boxes on the top of TVs. And so maybe they're not going to know. And, you know, that's a fair question. But in this case, I think that we can just give – I would recommend that they give their clients one set of advice, and that is if anyone asks you to falsify the reasons for the contract and then on top of that says, do you mind backdating them as well, or is it okay if we backdate the contracts, I would say just give them some general advice that the answer is no. And I think that would pretty much, at least in the facts of this case, now I'm not talking about the other harder cases. This is not the hard case. The facts in this case, that would take care of what happened, I think, in this case, at least as alleged by the plaintiffs in their second amended complaint.
Let me just add that if you had the fee rule that most of the world has where loser pays, and you as a plaintiff's law firm decided you were going to sue Sullivan and Cromwell with some frivolous claim, and it turns out you can't prove they knew, and you paid their hourly rate, that wouldn't be happening very often, except for in cases where it was pretty clear that the lawyers knew. So I think it's, once again, some issues we have to deal with on the procedural side that are affecting substantive plaintiffs' rights adversely.
Okay, Professor Painter, I actually have a question related to one of the last things you talked about. You said that you didn't think it made a lot of sense to distinguish between the secondary actors and the ones that are primarily responsible for committing securities fraud. Now, if you were writing the rule, and this goes for the rest of the panel as well, I'm wondering how you would apportion liability in a situation like that. If you were going to say, okay, vendors can be liable for securities fraud, would you try to apportion liability so that they were only responsible for the portion of the wrongdoing that they were personally involved in, or maybe joint and several liability? And I think that that's actually relevant to this case because the damages in this case I think that are sought are close to $7 billion. And what we're talking about with the vendors, my understanding is that it's around $17 million worth of transactions. So how would you go about apportioning liability in circumstances like that?
Congress tries to deal with this in the 95 Act, and I think it needs to be revisited. This is an excellent example of something that needs to be dealt with legislatively. You can't have courts that are coming up with a formula as to what the best cap is. I mean, there ought to be a cap. You can't have an entire law firm be sent down because one associate did something they shouldn't have done. Maybe a multiplier of the fee that was charged by the firm. You could come up with all sorts of formulas here. The 1995 Act gets into the issue, and we could continue to try and work with that, but it needs to be dealt with legislatively. Yes, there ought to be a cap. It ought to be a reasonable cap. And, of course, it depends on whether – the big problem is that the primary violators often are insolvent. The Enron's gone. There's no money there, so you're going after the deep pockets. We see it in Section 11. Congress dealt with it. The underwriters were liable for the total amount of their share of the underwriting, I believe. So, Congress can deal with this issue, and we can have a debate about it, but we need to have that over in Congress, not with the courts.
Yeah, this case is a nice illustration of what I alluded to earlier, the loss causation issue, because the plaintiffs' class covered, as I recall, a couple years. And this wasn't the only transgression. There were lots of ways they were fooling around with the numbers. So, in fact, the fraud involving the vendors only related to 1 quarter, related to projected cash flow for 1 quarter. And so that's a very, very significant loss causation issue. And I agree with Richard. These are they're just messy issues that the court's not going to do well with.
I have a question about the $7 billion figure that is being kicked around by the defense bar as the damages in this case. I look at the plaintiff's reply brief before the Supreme Court, and they say, and I quote, "Aggregate damages in the case do not approach the fantastical $7 billion suggested by respondents. As the district court explained, the $146.25 million partial settlement that it approved constituted 32% to 93% of the estimated recoverable damages." End quote. I wonder why it is that if the plaintiffs are not contending that the damages even remotely approach $7 billion, all of the briefs that are being filed by the defense bar and their amici are saying that the damages in the case are $7 billion.
I, of course, have no idea why they're doing that in their briefs, but I will just venture one comment, and that is this. I do think one thing that is a sympathetic fact in this case, it's a policy issue. It's not a legal issue. It's not what does deceptive device mean in Section 10b. But one sympathetic notion here, which is why the pleading standards have become so difficult, is that companies are afraid to try these cases. Companies, vendors, anybody is afraid to try them. And they're afraid to try them because ultimately, whatever the number is in this case, ultimately the amount of damages requested is usually some notion of here's how much the fraud cost each shareholder when they traded, and let's just add that up times every shareholder who traded during the class period, and you get these very large numbers. And companies simply won't take the risk of taking it to trial with the possibility that a jury will come back and say, well, you owe $22 billion to the plaintiffs. And so there is a notion here, I think, that if it gets past the motion to dismiss and it gets past the motion for summary judgment, I think maybe there were a couple cases tried in California in the last 20 years, but essentially none of these cases are ever tried. So the amount of damages, I think what the vendors are afraid of here is if it gets past the motion stages, they simply don't have a choice in terms of trying it because the number, whatever it is, whether it's somehow apportioned or it's the full amount, they'll be forced to just settle it. And they'll, of course, take the position that it was a meritless case that they were forced to settle. And the numbers here are big. They're big. Whatever they are, they're big.
Well, and just as a follow-up to answer your question, I don't want to get into a factual dispute about how much is being asked for and how much isn't. I was just using that number because that's what I saw in a number of the briefs. So to the extent that it might be higher or lower than that, I'll take your word for it. The basic point, I guess, is really just what we're talking about is the two vendors' actions for a limited period of time that is, 1/5 or 1/8 of the amount of time that the primary violator is alleged to have been doing a number of different things. And so the amount of, even if they've done what they've alleged, the amount of money that we're talking about with the vendors is significantly smaller than the overall alleged conspiracy. So that was...
But this is a serious concern that's why the investment banks and many are very worried. You have huge operations like Deutsche Bank and Citibank with thousands and thousands of employees doing deals, and you may have some bad apples. And the question is, do you sink an entire operation because of some bad apples? We chose to do that with Arthur Andersen, the prosecutors did, and I'm not so sure that was the wise move on that level. Do we do that in the civil liability regime? And that's why some sort of cap on damages. Why in the 33 Act saying, well, look, you're only liable if you're an underwriter for the amount of the securities you underwrote. Not your fee, but the amount you underwrote of the securities. They're trying to come up with some reasonable formula so the penalty is there, people can be sued, but then they can go about business instead of shutting every operation down, and you won't have anybody left on Wall Street.
Yeah, having said that, there's an article in the University of Chicago Law Review that came out this year that represented that almost all securities class action lawsuits are settled for within the amount of liability insurance that the company has. So plaintiffs, they allege a number that's quite big, but ultimately when the case settles, it's usually within the policy limits of the liability insurance policy, the D&O insurance policy.
Those are for director and officer cases. Is that just the D&O, or does that include lawyer cases and some of the others?
This they just looked at D&O.
D&O,
yeah.
Well, of course, there the directors and officers don't personally have, unless it's Warren Buffett or somebody, but they're usually in the millions, not in the, you really got to see the big B number there these days to make the case get headlines.
Do we have any other questions? Professor Adler?
Professor Painter suggested that he thinks the Supreme Court is likely to side with defendants in this case. I'm curious if the other panelists want to share their predictions or thoughts about what they think the Supreme Court is likely to do, and what, if any, significance should be attached to Chief Justice Roberts' decision to, I guess, presumably sell stock, and so he would no longer be recused from the merits of the case.
This is very interesting. One of the little-known facts in Central Bank was that when that case was appealed, and by the way, it came out of the 10th Circuit. I'm from Denver, and the lawyers in Denver were the ones that handled this. I had lunch with one of them the other day. And what happened was when that was going up on appeal to the Supreme Court, they were just arguing about the standard for aiding and abetting liability. Mm-hmm. It was the Supreme Court that came back and said, oh, by the way, brief whether aiding and abetting even exists in 10b. So the parties, the petitioner in that case, didn't even raise that issue ab initio. It was raised by the Supreme Court. So the Supreme Court interjected itself in. I think Justice Roberts' recusing is very unusual, and I think it's very clear he wants to sit on this panel and participate in this case. One would imagine that he has some idea of how he wants to come out, and he wants to make sure that his vote is counted. The thing that is the most troublesome to me about the Supreme Court justices in this is that the majority in central banks, so the three that we have left, Thomas, Scalia, and Kennedy, they emphasize over and over, it's the language of the statute, it's the language of the statute. Well, even the government, the Solicitor General's brief says, the key language is, what's a deceptive device? And the government says there's no way to read, using a dictionary or using existing Supreme Court cases, to read that phrase, deceptive device, any other way than to say it doesn't just cover disclosure violations, it also covers behavior. So, if the majority in central bank sticks to its approach. The dissent didn't say you have to limit yourself to the express language of 10b. If they stick to their approach, they have to look at what deceptive device means, and they have to interpret it based on some method of interpretation, and Scalia often uses dictionaries. So we'll see whether he can pull out of a dictionary some way of reading that language to say it doesn't cover behavior. The government says he can't do it. So we'll see. And I think we'll be able to tell from the questions on Tuesday which direction they're moving in, because if they're not really focusing on the language, but they're focusing on the policies or the effects, I think the petitioners can just assume they're going to lose.
Yeah, I think, I mean, I'll make a prediction. I think it's going to be for the defendants, and then we just have to figure out how they're going to get there. And they do have problems with the language of the statute. They can certainly reach out, though, and get to reliance issues, get to loss causation issues, and once you get, and they're happy to reach out in appropriate cases to get to those issues, and there's certainly a lot of discussion about those in the briefs. So I think we'll have to wait and see how the argument goes on Tuesday, but I can't imagine that the plaintiffs are going to win in this case.
Before I went back and teach, I was the ethics counsel in the White House, and I did work with the judicial nominees, particularly the Supreme Court, on their stock portfolios and these issues. I won't get into specifics on anything, obviously, but I can say what the rule is. Obviously, if you hold the stock, you're going to have to get rid of it, the stock, or recuse from the case. And a judge really has an obligation, if they can, to participate in a case, particularly in the Supreme Court. And if they can sell the stock without undue hardship, that's what they ought to be doing. And I think that's, so I don't think we ought to read into that, gee, he wants to jump into the case because he wants to side with this party or the other. He has an obligation. And I know some of the justices have very large portfolios, or their spouses have large portfolios. And sometimes that's triggered recusals. Sometimes there hasn't been a recusal, or there should be. The bottom line is that the justice should, if they possibly can, dump the investment. I wish they'd all be in mutual funds, including Vanguard. We went through that one. We really, I don't think I'd read much into that.
Boy, I just disagree. I have to defer to Richard's experience, and I certainly agree that I think justices ought to decide these cases, and they ought to not have a conflict of interest because of stock ownership. The issue here is not that Chief Justice Roberts sold the shares. Presumably, that's the reason he's no longer conflicted. They don't disclose the reason, so we sort of surmise that's the one. It's that he did it a couple of weeks before oral argument. So, that's the thing that allows us an extra set of facts to read in that, boy, he really must won in this case. He could have done it at the time the cert petition was filed and before they decided to accept it. He could have done it at a time when the plaintiffs and the petitioners and respondents wrote their briefs, and they might have been willing to put some arguments into the brief that were sort of designed particularly to influence justices, but didn't do it because they were effectively recused from the case. So I personally read into this a desire to make sure that his voice is heard in a particular way, but only not because of selling. I agree that that's the appropriate thing to do, but because of the timing of the sales.
Yeah, I mean, there are lots of cert petitions. Very few actually are granted. Now, I would say just stick the judge in mutual funds and get rid of these individual stocks. That's the way to go. But if you're not doing that, I guess I could see the argument. I don't agree with it, of holding on to stuff until the case actually reaches the latter stage. I'm not going to, I think the timing here is not great. But still, once we're at that point in time, I would be really upset with a justice who said, I got to hold on to the stock, and I'm going to sit out the case. I'm going to have 8 of them, and there's 4. That's going to make it even messier. It's a mess as it is.
So you're not happy with Breyer?
Well, I think
names.
they should all participate if they possibly can. They really should. That's part of a judge's obligation. If there's a way to work it out, they can get in there and participate. Do it. That's what you've agreed to do. If you want to play the market, your spouse wants to play the market. There are plenty of other jobs, and there's some people who want to sit on the court.
Was there a follow-up? Okay. Does anybody else have any questions? We have time for one more. Well, then, to head back to just central bank, to what extent do the three of you think that central bank will be controlling in this case, as opposed to the justices having to maybe break some new ground?
The facts of central bank are just so different. Again, that was aiding and abetting. There was no allegation that the trustee committed any fraud. Really, the issue was, was it reckless in not insisting on getting an appraisal prior to the second issuance of the bond? So to me, they're not very similar at all.
I think that, I would have said that the way the court would decide this case would be to rely on that language that Barbara read that sort of said either manipulative or some sort of disclosure violation that's in central bank. The court would have just cited its own opinion and said we're done. But I think the Solicitor General's brief that basically said it's not the case, that it's only disclosure, again makes it very hard for the Supreme Court to do that. And I think the language of the statute makes it very hard for the Supreme Court to do that. So I think the way the court will come out on this, if it chooses to side with the respondents, with the respondents with the Eighth Circuit, they'll find that there has to be reliance. And so the case that will actually get cited the most in this case will be Basic versus Levinson, which is the key reliance case that the Supreme Court has decided. So I think that will actually be a more influential case ultimately than central bank.
Central bank, the way I would argue it should have been resolved was scienter, the lack of scienter, certainly no intent, and if recklessness is going to be defined to encompass the conduct in central bank, that's a very broad definition of recklessness. That's the route I think the court should have gone rather than this aider and abetter versus primary violator distinction. Once we're locked into that, it's going to be tough. You can distinguish the facts, absolutely, between these two cases, but it's going to be tough to come up with a predictable rule of law that distinguishes the two. The clear rule I would have, I think I mentioned, is the person who makes the misrepresentations to investors, who actually speaks to the investors. Yes, you could have a recklessness standard there, but all others knowing conduct, period. Did they know or did they not know? And if they didn't, as in, I believe, central bank, they shouldn't be liable.
Well, thank you for your participation today.
Thank you.
And we will take a short break for 15 minutes and reconvene with our second panel at 10:30.